this evening to listen to what I have to say. It's been a long day. We'll just extend it a little bit longer. A little bit about me. If you picked up the gray and blue card at the sign-in table, just real briefly, I am a former Texas public school educator. I was a teacher, a principal, and a central office administrator. Did that for 17 years and thought, I don't like where this is going. So I went to law school, and now I practice school law. So I represent teachers, parents, and students all the way from preschool through medical school. I've had clients. And it's still very important to me to advocate for teachers and kids. I'm just doing it in a different venue now. So that's kind of my background. And just because the theme of the evening is who's running for what, if you enjoyed tonight's presentation and you would like to thank me somehow, if you know anybody who lives in Missouri City down in Fort Bend, I'm running for city council. The election is Saturday, so it's a welcome break from campaigning to come and be with you this evening. But if you have a friend down there, I'd appreciate the phone call to say, hey, this lady is different, she's refreshing, and that's what we need, so I'll agree with you there. So tonight we're going to listen to some commentary. I did not provide a handout with all the information in it because everybody has come tonight with a different purpose, and you'll be listening for different types of information. So I always make the joke that you can take the teacher out of the classroom, but you can't take the classroom out of the teacher. So you have a handout that you can fill in yourself. Here's the outline of the meat of tonight's presentation, but write down what impresses you, what means something to you, and that way you'll be sure to get something out of this evening's presentation. We're going to be looking at the current topic at hand, what has gone on at the elementary school. I would say from either 3 different lenses that we can look at the issue through, or 3 different measuring sticks. So let's compare the facts of the situation to these 3 measuring sticks. In other words, whose problem is this? Is this a federal problem? Is this a state law problem? Or is this a local administrative law problem? So we'll talk about that a little bit. Thinking about federal law, of course we know that the Constitution doesn't mention anything about education. It's silent on the matter, and so we can't really go to the Constitution for any guidance. However, what's important to know is that if school districts accept federal funds, then they automatically become obligated to follow a whole lot of federal regulation. You may have heard of OCR, and you may have heard of people filing OCR complaints. That's the Office of Civil Rights, which is a division of the U.S. Department of Education. So you can see on the screen that not only does the OCR protect civil rights of participants in federally funded programs, but they also address discrimination. Now, just on the onset, as I'm looking at the details this evening, I want to clarify that the facts that I know about the current situation in Magnolia is that this is not a discriminatory issue. It's not students who are being not allowed to walk home because they belong to one of those protected classes. But there may be some civil rights implications, which is why I wanted to mention OCR under the federal umbrella. There's also an interesting case that was decided by the Supreme Court in 2000. I do want to caution you that it had to do with parental visitation rights, and it was more of a family law issue. But the U.S. Supreme Court ruled in Troxell versus Granville that parents have an interest in the care, custody, and control of their children. So there might be an interesting link between the federal case law about parental interest and what's going on at this elementary school in Magnolia. So that's something to think about. As I was researching what has gone on over the last several months in Magnolia, and specifically at the school, I heard mention of the Every Student Succeeds Act, which in legalese is Public Law 114-95. You Google that and you Google section 8542, it's a really short section. the wording of the law says that the Secretary of Education is not authorized to prevent a child from getting to school, and it lists all the ways. Of course, I pulled out walking because that's the topic that we're discussing tonight. When the parents have given permission. Now, obviously, law is up to interpretation. That's what judges do, and that's what attorneys do. Without taking a position on a specific family's issue, because I haven't represented anybody here in Magnolia ISD, what this means, at least with my reading of that law, is that the Secretary of Education can't put any kind of requirement. For example, if we give you transportation funding and you buy buses with it, the Secretary can't make a condition of that funding so everybody has to ride the bus. If we're giving you bus money, you gotta ride the bus. The Every Student Succeeds Act does not allow him to do that. So he can't control how kids get to and from school. Now, that section also says that it doesn't preempt state or local law. So the feds don't take precedence here. There's always going to be deference to local control, especially school board decision making, which can be problematic. But I wanted to make sure that I put the language of that section in tonight's presentation, again, to maybe give you a topic to brainstorm about a little bit. If the spirit of the law at the federal level is that nobody can say how kids can get to and from school, is there legislative intent that should trickle down? Is that one of those interests that that court case could reinforce? So that might be helpful to you as you're grappling with this situation. Then we'll come down to Texas law. And of course, we do have the Texas Constitution, and there is a Bill of Rights in the Texas Constitution. Article 1 entitles everyone to equal rights, and it also says that a Texan can only be deprived of life, liberty, property, privileges, or immunities by due process. That's what due course means. Now, due process has kind of been watered down over the years, and due process now is a very lax requirement. Generally, that means just two things: that you get notice of what the problem is and you have an opportunity to explain yourself. Especially in the school setting, that's pretty much all you get. That's due process. But thinking back to the case law at the federal level, to what I'm going to call it the ESSA law, but you know what I'm talking about. Thinking back to those interests, privileges, could it be that the Texas Constitution is saying that in Texas, we recognize these interests and rights, and you can't deprive someone of them without due process? Have the families who are no longer allowed to walk to and from school gotten due process as part of this new policy this year? Something else to think about. Then we get to the Education Code, which is a really good insurance policy and protector for school districts in Texas. Written certainly to benefit the school districts, and written to, well, that's about the best way I can put it. It benefits the school districts because, of course, school districts have really strong lobbyists in Austin. There are 3 chapters from the Education Code that I want to bring to your attention, because as I was following the story unfold, these are the sections of the code that kind of came to light in my mind as, well, I wonder how, if we measure the facts against this, how would it stand? If we measure the facts against that, how would it stand? So those are the 3 we're going to talk about. First is Chapter 11, how school districts are governed. It's important that you know that Texas law requires site-based decision-making on each campus at a public school in Texas. Now, what that meant originally was that there was a committee of stakeholders, parents, teachers, business partners, and campus administration that would meet regularly to talk about different issues and different programs on campus. Over the years that that we've had site-based decision-making, what it has turned into is the principal is the CEO of that campus, principal's word is the final word, and that's pretty much it. And I can say that because I was a principal at 2 elementary schools, and so that's pretty much how we do business around here if you're a public school principal. However, it's important that you know that the law requires that the CIP, which is the Campus Improvement Plan, there is a plan that should drive what goes on at each campus in a public school district. That is supposed to be reviewed and revised annually. Well, did that happen at this particular elementary school? I'm not sure, but it's something to think about.
What is the CIP stand for?
Campus Improvement Plan.
And who reviews that?
The site-based decision-making committee, which is the stakeholders and administrators, so teachers, parents, and business partners should be on this committee. They're supposed to meet regularly.
Is that a public document
Yes.
that would supposedly be on record at the school district?
Or is it on our school website?
It can be on the school website. It should.
I have a teacher.
You're at a different school.
Yeah, I'm in public.
Yeah.
Gotcha.
It should be available probably for review in the school office, or you can always request it through a Public Information Act request. So there should be a parental involvement component to the campus improvement plan. I don't know what that looks like at this particular campus, but it could be something that you'd want to consider. And then the law is very clear about the areas that this committee should be involved in. One of them is school organization. Now, I'm interpreting that to mean not the school as an organization, but how the school is organized. And wouldn't it be reasonable to connect arrival and dismissal procedures with how the school is organized? So, where's the site-based decision-making committee at the particular campus we're talking about this evening? What did they decide about school organization? Did the committee have input in this as the law requires? We don't know, but that's something also that I wanted you to think about. Then we'll move to Chapter 26. Chapter 26 has been mentioned in this year-long or school year-long battle already, and that deals with the role of parents in education in Texas. The code says parents are partners with the school district. The code says that parents should be able to participate in the creation and implementation of educational programs. That might be a landmine. I would caution you from using that particular section or subsection of the code, because I would argue that dismissal procedures may not be educational programs. So don't fall into that trap. But the code also says that parents' rights under other laws should not be limited by the education code. So those federal laws perhaps should not be limited. And of course, no administrator or educator may limit parental rights. That's all in state law. Then we come to Chapter 37, and that's the discipline section of the Education Code. A couple of things that have come up in this several-month-long saga is the right of an administrator to refuse a parent entry, either into the building or onto school grounds. Well, you have to have legitimate business. And I would say that it's arguable that picking up your child who is enrolled at that school is legitimate business. So you meet that first element. Everybody always has the question, it's public property, it's a public school. Not necessarily, because the code defines the school property as any property under the school board's control. So it's public property in the sense that it's a public school, but if it's under a school board's control, then they have a say-so in who can come on to campus or to a stadium or even to central office. And so, school district personnel have the right to eject any undesirable person. As a lawyer, I really despise those super general terms. Who gets to decide what's undesirable? Who's undesirable? Is the rule the same for everybody? That's pretty broad language for a law, but that's what passed. Then we have another section of the discipline chapter of the code about trespassing. And there's been some controversy about trespass warnings and other trespass questions in this particular situation. An unauthorized person may not be on any of that property that's controlled by the school board. Under the education code, trespass on school district property is a Class C misdemeanor. And again, I don't know any particular families, specific facts, because I don't represent any families in the school district. But my understanding is that constables have been saying that it's another class of misdemeanor. Well, look up the code, it's online. It's a Class C misdemeanor if it's education related. The penal code, however, says that trespass is if you enter onto property or remain on property that you've been given notice to either not enter or remain on, or if you've been asked to leave. So there's a difference between the education code and the penal code. Class C misdemeanor is punishable by a fine of no more than $500.
What about the penal code version of criminal trespass?
Those are either, now let me think. I may have reversed that. I think a class, no, that's right.
No, Class C is the
Class
lowest.
C is the lowest, and that is punishable by a fine.
Right.
A and B is punishable by state jail time or a fine, I think.
Right.
No?
Oh, that's
B
true.
is
Yes.
$500 fine, it's a fine of up to $2,000.
Oh, it's just-
Up to 6 months in the county jail.
Oh, county,
And a
okay.
B would be, for it to be an A, it has to be a habitation.
Oh, okay.
And there is a state jail trespass, and it's like a superfund side, stuff like that.
Oh, okay.
So this would be, if they charge it as, under the penal code, it would be a Class B.
And that's why I don't practice criminal law. I
Which is
practice civil law.
6 months in jail potentially.
Potentially, yeah.
$5,000 fine.
2,000.
2. Okay.
When you say an unauthorized person,
Uh-huh.
is that also left up to interpretation?
Yes.
Because you could say, I'm a parent, so my parent have a reason for being there. Is that why it's so vague?
Yes?
That's when you hire a criminal lawyer, right?
Right. Yeah.
Well, I think sometimes an unauthorized person too would probably more frequently be used in a situation where you have a parent that is not supposed to have access to the child, who, a non-custodial parent.
That's if you're dealing with a reasonable person.
Right. But I'm just saying that's, I think, where
Yeah.
probably more often.
And that's the power of us all getting together and having this conversation, because I don't do criminal law, and it's been a while since I took the bar exam when I had to study it, so I appreciate your input. Yes?
I cannot imagine any jury that would convict a parent of the facts as I know it. I mean, if they can, you may have to go for the ride, but I can't imagine.
Agreed. The problem is, though, going for the ride
Yeah.
and the time and expense
Yeah.
that you have to go through, so,
Oh,
yeah.
yeah. It costs you thousands of dollars.
I respect that you think that, but I will tell you that my opponent would say that a jury should not have the discretion to make that choice, and that most prosecutors would argue that once you're seated as a jury, even if you disagree with the law, if it is proven that a parent was unauthorized, that they have an obligation to convict.
Well,
And the court would likely, and
yeah.
some judges would not allow a defense lawyer to make the argument.
Yeah, I know there's a lot of prosecutors that don't really care about the Constitution. I agree with you that.
Yeah.
But the thing is, you don't even have to go to constitutional principles. You just have to go to the vague definitions
Right.
here and argue all that stuff. And I just can't see a jury buying any of that. establishment. So,
And the good thing is that in this particular situation, no one has been arrested for trespass, no one's been ticketed for trespass. I think one person reached a warning status, but thank goodness nobody's gotten to that point yet. So let's hope that it doesn't get any more serious. Here's,
Question, if you don't mind.
oh, I'm sorry, sure.
Please, if I'm starting to go down a rabbit hole, please just tell me that.
Okay.
I was at a campus carry event for Cleveland College. They're still deciding on their policies coming next year.
Yeah.
And so when you said that the campus is anything that the school board can control, if a school is renting property from a college during the day, at night when the students are no longer there, does that, how would you think that would work? Is it college property again, or because we have a lot of schools that mix the college and the high school on the same campuses and the same locations?
Like they're renting property, like.
I want to say that I don't have enough information to take a stand one way or the other because I wouldn't want to give you wrong information. That's one of those special situations that we're going to have to wrestle with. Yeah. So I agree with you. It's probably a problem.
Okay, thank you.
Here's the biggie. And I hate to be the bearer of bad news, but under Chapter 37 of the Education Code, the school board has the authority to adopt rules for the safety and welfare of students and other people. Okay. Do you see what the problem is with that statement?
it's the board, not the principal.
Pretty obvious, isn't it? So that's something that I want you to be aware of also. Yes?
What if the board has not been involved in the decision-making at all?
Well, then I think that's a problem. Yep, that's what the code says. And I know there was some question about cars having to park at this particular campus and then like go get your kids and then go away, whatever the whole parking thing is. But again, the Board of Trustees can adopt rules that govern operation and parking of vehicles as well. But you might want to make a notation of this particular section of the code.
Does it have to be uniform? I mean, they would have to make that policy for all elementary schools.
You would think,
And
yeah.
not just like, okay, everybody else but you,
Right.
this campus has to.
Right, I mean, generally that's how school board policy works.
Right.
Yeah.
And sometimes when they get vague where there's a general policy, but then it's up to the discretion of the principal on how it's implemented.
Yep. Yep, but that's the language of the law, so you guys know. So moving down to the school board and local policies and regulations, you can find MISD's, yes.
I have a question. So does the Texas law preempt local law in education?
Well, so in education, there's really no local law. It's all policy and regulation.
Okay.
So the rules that govern.
It's like the law has that 37
Well, there's
right there.
none of
Yeah,
it's
yeah,
a
that's
law.
the law.
So that's like, okay.
Now, I will tell you that the state level will defer to school board control and decision because they believe that the school board should govern their school district. But when you get down to the local policies, they're policies, not laws. So they don't maybe have as many teeth or as sharp teeth as the state law.
Okay.
To find board policy for MISD, you go to the website, click on About, click on the school board, and then you'll see a link to board policies. That's an important set of documents that if you have a child in public education in Texas, you need to know where the board policies are, and there are some that you need to be familiar with. Not just Magnolia, but any school district in Texas. So a couple of board policies that relate directly to the problem that we're discussing tonight. The sections in board policy are not numbered. The different chapters are coded by letters. So for example, section D is about employees. Section F is about students. So section B is about governance. And board policy BQB governs campus planning and decision making. So now that you know a little bit about what the law says about site-based decision making, now you can go and look at what the district policy is about site-based decision making. Section G is about, well, GKA is about conduct on school premises. And I know that there's been some talk in the discussion about this particular issue about somebody was disruptive. There's a definition or some examples of what disruptive activity is in board policy GKA. So you might want to go look that up as well. But here's the most important one, that every parent with a child in a Texas public school has got to know about now before you need it. And that's policy FNG. That's the parental complaint or grievance policy. It is designed to be under the radar. I get calls at my office all the time and I'll tell them, well, did you file a grievance? Well, no, they didn't tell me about that. Well, of course not, and they're not going to. You've got to know about it before you need it. The problem is that you've got to file your first level of grievance, at least in Magnolia, within 15 school business days of the time you knew or should have known, there's a broad term, of the problem giving rise to the complaint. So if you don't know about this policy, you try to resolve it informally, and your 15 days expire, you're out of time. And the district can reject your grievance on the basis of timeliness. Now, particularly Magnolia, because I got this information from the Magnolia ISD Board Policy Book online, they say that informal resolution, i.e. going to talk to the principal, having a conference with student services, going to speak with the superintendent, those kinds of meetings are encouraged, but that's not going to extend your deadline, your 15-day deadline. So, what do most parents who aren't aware of this policy do? They try to work it out with the people they know have the power to probably fix it. Then their 15 days expire, then they have no other recourse. That's why it's important to know about this before you need it. Now, some school districts are kind enough to provide the requisite forms online as part of the policy. That's generous. Magnolia ISD does not provide the form that you have to use to file your grievance. I searched for it on the website. I queried it. I went through the policy. I went to different department links on the website. It's not there. So I don't think it should be that hard for parents to find the form. You probably are going to have to get on the phone and say, I need the FNG form. Because you have to use their form. So where is it? So be aware of that too.
F&G.
FNG form. The FNG form. There you go.
Request number 6482 to get the FNG form.
So there you go. So,
But I would also add,
yes.
having been an educator, that they can delay this. You can get a voicemail. They can take time to return this call. They just need to wait the clock out. So I would suggest personally, having been an educator and dealing with issues, start off by getting the form, filing the form, and then going through the informal process where the form is at least on file. Because they can delay it. The principal can go, okay, I can meet you next week. That just killed, 5 days of your time frame. I think everybody wants to be nice, everybody wants to be civil, everybody wants to handle things in a polite way. Let's just talk this out. But I find that, unfortunately, the theme now in public education, I've seen a lot of changes in my time in the classroom, is you're dealing with more of a politician-run school and school district than the old, let's take care of the kids kind of.
Right.
Looks like you need to ask for a form the first day of school.
I'm just going to give a couple of blank forms.
Well, but you don't want to get a target painted on your back. I have called school district offices and said, I need the form. And the secretary will say to me, who are you and why do you need it? I'm asking for it, but that, so be careful, but you need to know about that. So those are the three lenses, yes.
Would you ever file a public information request for that form?
You
Well,
shouldn't have to.
You could, but you should try to ask for it first, that's easier. I mean, it's faster, because they've got a certain amount of time to respond to the TPIA request.
I think it's like 6 months, right?
It can be. I don't think there's any definition, I think the law says a reasonable amount of time, so there you go again, yes.
Susan, what is it necessarily, if you fill out that form within the 15 days, what are they obligated to do? I mean,
Well, see, that's the good thing. They don't want you to know about FNG because they are obligated under the policy to do certain things within certain time frames. So you're not left flailing around for days and weeks on end. They have a certain number of days within which they need to schedule the level 1 hearing, then you have it, and then they have a certain number of days to issue their decision at what they call level 1. Level 1 is at the lowest level of administration that can take care of the issue. Generally, that's the campus level. If you don't like the decision at level 1, you appeal to level 2. That's generally somebody in central office, and you can probably guess how those decisions usually turn out. And then again, they've got a certain number of days to schedule the level 2 and a certain number of days to respond to you after the hearing. And if you don't like the outcome of level 2, you go to level 3, you appeal to level 3, which is generally in front of the school board. And again, they need to listen and they need to take a vote to either accept or reject the lower
that's not
decision.
under the Open Meetings Act. That's a different thing, right? Going before the school board, you're not talking about just going before them at an open meeting.
No, right. Sometimes they schedule them before regular board meetings, and sometimes they have to call special meetings to
Okay.
meet that timeline.
Okay.
So, yeah. Good
Might go in
questions.
an executive session or something, or it would just be totally separate from the opens meeting?
Totally separate
Okay.
from the regular
Okay,
meeting.
thank you.
Yeah. Generally closed because personnel matters are confidential in Texas, and of course, student matters are confidential.
Okay,
Generally in a closed meeting, but nonetheless, it's a separate board meeting.
okay.
Yeah. So those are the three lenses that we can look at this current problem through: federal, state, and local. But I want to leave you with some questions that made an impression on me, and some facts of the current situation that made an impression on me. And if any of these are meaningful, you might want to jot them down as well. So I've seen a picture of a notice from the school that's entitled the 2015-16 Car Rider Rules. And it says, in writing, students will not, and that's exactly from the policy, that's not my bolding and capitalizing, will not be dismissed to people on foot. That's how the school year started. That was the policy, not. But then I saw a social media posting from Representative Bell that says, well, that was never against MISD policy. Okay, what is the district policy about departure and arrival at school? And is there MISD policy? Because remember, the code says that it's the school board who makes the rules about student safety. I don't think that happened here. This is a campus policy. So that struck me as interesting. I've also seen references from the school district that say people received letters. But then there also have been reports that there were actual trespass warnings. There's a difference. Nobody wants to get a letter from the school district slapping your hand. But from the legal standpoint, that's not the big guns at all, so don't worry about a letter. It could be construed as a warning, so you have to be careful. But that's different from a legal trespass warning. Then, this was really interesting to me. There's been a recent attempt by the campus principal to link parents who are picking up their kids to the truancy law in Texas, which, as an attorney, I'll just say I don't think one has anything to do with the other. But you need to know that the truancy issue is near and dear to my heart because I'm on the team of attorneys that filed a lawsuit against Fort Bend County and Fort Bend ISD for their illegal truancy practices. And the lawsuit and all the work leading up to the lawsuit is part of what helped decriminalize truancy in Texas. And we're very proud of that.
Thank you.
So I know the truancy law inside and out, and taking your kid home, especially at dismissal time, has nothing to do with the days or parts of days that kids might miss, and that's the language of the truancy law. Parts of days, and if they're going to use that you sign your kids out 5 minutes early, I don't think that's real reasonable. But for sure, picking your kids up from school after the bell rings has nothing to do with truancy. Couple other points before we wrap things up. I saw a redacted superintendent email that said, this is a quote, "We have made a decision about this policy, like it's going to remain, based on our definition of a safe, orderly process." Now, I can guarantee you that that language was used intentionally because I'm sure that the superintendent and the school board have been in touch with their legal counsel. You saw the language of the education code. They can make rules about safety. But the superintendent said "we," and we know that this hasn't gone before the school board. There's no policy, so who's the "we"? And if he's admitting in an email, "We made a decision," I don't think under the education code we can. The school board can. And then there's another superintendent email that I've seen that says that this policy is consistent with other elementary schools. Well, I don't know if you've taken a survey, but from what I hear, other area schools have walkers, bike riders. So I just would like some more information about this, and so that's the point for you to ponder. Yes?
Do they have walkers and bike riders at that school? Because I'm just speaking from my personal, our school experience. We have front walkers, back walkers, and front car riders and back car riders.
Uh-huh.
And as a car rider, we don't release the parents because we don't want the kids going across in front of cars. Because parents will do that, try to get out of their car and try to pick them up
Oh, yeah.
to avoid standing in line or waiting with the front walkers.
So
So
are you
do they
saying,
have a policy for front walker, like a walking policy?
you mean the campus where
Yes,
Bear
because
Ranch?
you showed their car rider policy, but what is their student walker and biker policy?